Professor LLB from the University of Dalhousie, which I understand is somewhere in the Maritimes, was called to the bar in 1974. That's the Bar of Ontario. Has been employed since 1974 in various capacities with the Ministry of the Attorney General. I want to recognize publicly that with particularly the kind cooperation of the then Deputy Crown Attorney for York, Mr. Sam McGee, another debating partner, we were able to introduce the presence of a Crown Attorney on a full-time basis at the then called Juvenile Court in Toronto, a practice that has since expanded to most of the jurisdictions, I must say, thankfully. And part of that program was essentially the product of the work, dedication, and devotion that Barbara Ferns brought to the position. She has recently been a member of the Young Offenders Act Advisory Committee for the Ministry of the Attorney General. We're still hoping that some of the practical questions that you and I have and will continue to have will be addressed by this committee and others so that the work can proceed with a little bit more effectiveness. Barbara Ferns.
I'd like to introduce my two panelists on this particular subject, and they are Mike Lynch and Fred Shanahan, if they'd like to come forward. It seems to be fate with me that every time I'm on a panel on this particular subject of transfers to adult court, that the person that represents a senior position in the Crown Attorney's office is on the verge of leaving the office. The last time I did this, it was Mr. Bob McGee, and today I'm pleased to introduce Mike Lynch to you as the Deputy Crown Attorney for Scarborough, who I understand is going to be leaving our office as well. So it's unfortunate for us, but I'm sure a welcome to you, members of the private bar, that he's joining you on that side of the court. Michael graduated from the University of Western Ontario in 1963 with his Bachelor of Arts degree. He went on to Osgoode Hall Law School, where he received his degree there in 1966, and he was called to the Ontario Bar in 1968. He joined the Crown Attorney's Office in Toronto in 1968 to 1973, and from 73 to 76 went into the private sector in the firm of Austin and Murphy. He came back to us in the Crown's office in 1976 and became the Deputy Crown Attorney in Scarborough, and is here with us today in that capacity. As well, we're also joined with us today with Frederick Shanahan. He is sole practitioner in Toronto and attained his undergraduate degree from the University of Toronto and St. Michael's College in 1970. He went on to the University of Toronto Law School and graduated from there in 1973. He obtained his call to the bar in 1975 and has continued his practice in various fields in Metro Toronto. No doubt is gaining notoriety as a result of being representing some of the families at the Grange Commission. I also had the pleasure to do one of the transfer cases with him, Regina and Clovis Pilon, with him as counsel on that case, so he's had experience in this field of transfers. I might indicate to introduce the topic to you that if you've been only following the press releases on this act, you may be under the impression that the Young Offenders Act applies to the young people between the ages of 12 and 18 in the province of Ontario. That's not correct. If you are practicing in Ontario, the age group that this act deals with now is 12 to under 16. We are still operating under 16 until April of 1985. At that time, we'll be dealing with the full population under this legislation, 12 to under 18. So the concern, certainly from the public and the police and those involved in law enforcement was, well, how can you deal with these serious criminals who are relatively mature in age, if we look at the age from 14 to 18, and only have them subject or accountable to a maximum of, say, 3 years of custody. Certainly we have a significant number of murders committed in that age group and of serious crime committed in that age group. Well, to that end, the Young Offenders Act incorporated the same type of provisions as we found in the Juvenile Delinquents Act. So anyone over the age of 14 could be the subject matter of a transfer to adult court. And there we have the rules that apply there. I might say in answer to Mr. Justice Ewaschuk's comment on what might happen as to those issues of statements and possibly a young witness who might be an important witness in a murder case, for example, and you were looking at a transfer to the adult court because your case would be much stronger and that the rules of evidence had not been strictly complied with, for example, in a statement situation, or say if you didn't have the corroboration needed, but yet you felt your witness might be a sworn witness in the adult system. Would they apply? Well, I think the Crown could at least make an argument, perhaps not persuasive enough, but there may be at least an argument under Section 16, Sub 8 and Sub 7, because there it says that if you are transferred to the ordinary court, that the proceedings under the YOA are discontinued, and the young person against whom the proceedings are taken shall be taken before the ordinary court. And there might be room for an argument to be made there that if you are proceeding in the ordinary court, then it's the rules that apply to the ordinary court that govern the prosecution at that time. Of course, there's the other side of the coin that was stated, and we'll have to wait and see what the judicial comment is on that. I'd like to turn now to Mike, if I may, and ask him to familiarize you with the application itself.
Thank you, Barbara. This application used to be noted under the old Juvenile Delinquents Act as Section 9. And with reference to that section, I don't know if you have your codes with you with the act in it, but I'll just briefly read it to you because it will bear some further examination as we go along. Section 9 said that where the act complained of is under the provisions of the criminal code or otherwise an indictable offense, and the accused child is apparently or actually over the age of 14 years, the court may, in its discretion, order the child to be proceeded against by indictment in the ordinary courts in accordance with the provisions of the criminal code in that behalf. But such course shall in no case be followed unless the court is of the opinion that the good of the child and the interests of the community demand it. That was the primary operative section. Now, Section 16 under the new Youthful Offenders Act is the reenactment of that Section 9. Section 16, as it is presented, represents primarily a good codification of the common law as it applied to Section 9 hearings. And I hope will bring some order and formality to the rules of the game in the juvenile court with the various judges. The hearing itself under the Section 9 was originally quite a complicated hearing, and I think with respect dealt primarily with the most serious type of offenses, murder or rape, perhaps a very serious aggravated assault or armed robbery. And because of the necessity of presenting evidence of various factors that are now codified under Section 16, you could reckon on a hearing taking perhaps a week, sometimes more. Now, the situations that I believe the Crown will make applications under the new Section 16, I would expect will be relegated still to the most serious charges. Or where a co-accused, an adult, is presently before the adult court, jointly charged with the same offense. Of course, the application is no longer one made by the Crown. It's now under Section 16 open to the defense to make such an application. Mr. Shanahan will have some comments I expect about that. The hearing is just that. It is not a trial. I suppose by way of comparison or analogy, we might compare it to a bail hearing. And the rules of evidence are much less stringently applied. I would anticipate that under the new Section 16 hearings, the evidence that one would normally present perhaps will be somewhat shortened down by agreement or consent by both parties, whoever is making the application. The rules of evidence, as I say, are less stringently applied, and hearsay, which was permitted by case law under old Section 9, ought to be permitted. There should be no necessities of having a voir dire on, for instance, a statement. I expect that a number of matters will be agreed to by both parties. And the standard of proof, such as it is, my submission to you is a minimal standard of proof. We must satisfy the presiding judge that it is in the interests of the society and the needs of the young person that this be done. However, the old case law indicates that on dealing with both tests, the test with regards to the satisfying the interests of the public and the test to satisfy that it is in the need of the young person, must both be satisfied. We cannot just simply deal with one and not the other. Both tests are to be satisfied. Now, looking at Section 16 as it is, 16.1, at any time after an information is laid against a young person alleged to have, after attaining the age of 14 years, committed an indictable offense, other than an offense referred to in Section 483 of the Criminal Code, 483, of course, being offenses where the provincial court has absolute jurisdiction. So it does not pertain to those offenses. But prior to adjudication, a youth court may, on an application of a young person or his counsel or the Attorney General or his agent, after affording both parties and the parents of the young person an opportunity to be heard, if the court is of the opinion that in the interests of society and having regard to the needs of the young person should be proceeded against in the ordinary court, order that young person to be so proceeded against in accordance with the law ordinarily applicable to an adult charged with the offense. Now, just breaking that down a little bit, you'll note that he has to be 14 years of age or more. It has to be an indictable offense, not one in which there is an absolute jurisdiction. And the application must be made prior to the adjudication, prior to any finding of guilt being made. Now, there is a little difference there in the sense that the application under Section 9 could be brought at a later stage in the proceedings and well after an adjudication, but of guilt. But now the application must be immediate, almost. Now, you'll note again also the application is not restricted to that of the Crown. Now, one interesting thing here is the question of what role does the parents have in such an application. This is something completely new. Do they have the right to call evidence or cross-examine witnesses? Do they have the right to make representations to the court? My respectful view, I would think that they do. And that in terms of being able to do that, the court ought to be guided by the principles of administrative law, the principles of natural justice. so that I would think that they will have not an unrestricted right to do these things, but obviously are going to play a very full part, or could play a full part, in the proceedings. And of course, it will be interesting to see just what positions they may take. They may take positions both for and against either party, because their interests may be different from that of the child. However, that is certainly a major change. Now, another major change is also the standards to be applied. As you'll recall from Section 9 reading, that has changed in Section 16. Now the interests of society appear to be the first element to be satisfied, and the needs of the young person are the second element to be satisfied. Now, it's interesting to discuss, I suppose, whether or not that shift in emphasis in the legislative drafting will reflect itself in terms of the court's attitude to these matters. I suspect, given the experience, at least in Toronto, that it probably will not make any difference to the judges, the emphasis. Now, going on to the second part of that Section 16, there you have, in a codified form, as I've indicated, the nature of the evidence to be heard. The first one, of course, is the seriousness of the alleged offense and the circumstances. In that situation, the common practice has been to call the investigating officer to outline in detail what the allegations are. And in that case, he has been permitted to give hearsay evidence, the result of investigation by other officers that he is aware of. He has introduced confessions without a voir dire as part of that evidence. Now, of course, it may be that the Crown would be permitted, depending on the view taken by the judge, of simply reading a statement as he would perhaps in a bail hearing of the circumstances of the alleged offense. The second aspect, Part B, is the age, maturity, character, and background of the young person, and any record or summary of previous findings of delinquency under the Juvenile Delinquents Act or previous findings of guilt under this or any other act. There we have generally had evidence from his school. We've introduced school records through the principal or vice principal of the school, recalling that school records are privileged documents, that they would not be turned over to the Crown except at the court and for court purposes. The assessments, if any, that have been done in the past, either privately or through the courts, of psychological assessments, friends or neighbors who are familiar with this person, to give evidence of, I suppose, bad character from the Crown's point of view. Police officers who were involved in previous occasions with the youth that may or may not have resulted in an action of a criminal nature in the past. We've even gone so far as relating through police officers the circumstances that resulted in previous convictions. Of course, having regard to the limitation now imposed by this act as to the use of records, how far back we go it will be limited to that extent. The C part, under that sub 2, the adequacy of this act, the adequacy of the criminal code, or other act of Parliament that it would apply in respect of a young person if an order were made under sub 1 to meet the circumstances of the case. Recently, within the last year, we had one where a 15-year-old lad was charged with first-degree murder, and you can well appreciate the problem the Crown had in satisfying a judge that it was in the child's interest to go to the adult court for probably a life sentence with no parole for 25 years. In the circumstances of this subsection, however, you do need to hear evidence from the various correctional facilities. That also leads me to subpart D, the availability of treatment of correctional resources. If you have a serious offense, obviously the Crown is interested in looking for a sentence that will exceed 3 years, which is the maximum under the Juvenile or the Youthful Offenders Act. But we would call somebody from the National Parole Board to outline what facilities are available within their system for early parole, placements in various correctional situations, passes, day passes, which are quite topical these days, that would be afforded to an individual of such a youthful age in separating from the general criminal population. We would need somebody as well from the Ontario system to outline the procedures for parole and the facilities and resources available in the Ontario system. And then finally, of course, representations through the juvenile system itself, from Comstock, to indicate what resources they have available. This is sometimes has some interesting application, however. I recall specifically one where we had a lad that was probably going to go for a long time to penitentiary, and we did call somebody from Kingston Penitentiary to outline the circumstances, which he did, and we expected that he would, but then went on to talk about all kinds of horror stories that, so we didn't know quite how to deal with him. But there seems to be, I wouldn't say a predisposition by the various authorities to favor their own system to a certain extent. With due respect to the Comstock people, I certainly find them very strong in their view of maintaining a child in their system. So that these are all the aspects, of course, that the judge has to consider. Finally, as well, any representations made to the court by and behalf of the young person or the Attorney General or his agent, that's simply the argument, and any other factors that the court considers relevant. Well, the court cannot, according to the case law at least, operate from its own experience or knowledge, but certainly it doesn't operate in a vacuum either. But that's a pretty basket clause catch-all for everything. Now, one other thing, too, is under sub 3 of that section is the predisposition report, which now has to be undertaken in considering the application. A youth court shall consider a predisposition report. That was not necessarily so under Section 9 under the old Act, but it is now a prerequisite as part of the evidence to be considered. Now, I anticipate as well that there may be an opportunity to waive hearings in front of the juvenile court judge. Although it remains to be seen, it may well be the judge may want to hear some evidence to justify the waiver. But I expect at least that the whole proceedings will be streamlined to quite a certain extent and cut down the time necessary for what used to be a very cumbersome process. And I expect will give some guidance to the judges, which seem to have a variety of views in these matters, depending on who you're dealing with.
Thank you, Mike. I wonder, Fred, if you might comment at this time with respect of the defense tactics and the defense point of view when they might want to consider bringing an application into this section.
I'll try. Barbara, in introduction, was very kind to me. I had a case with her. She failed to mention that I lost the Section 9 transfer hearing, that I appealed it and I lost that, that my client was found guilty. He was then sent to jail, and he never retained me ever again. So there you are. I really am well qualified here to tell you about Section 9. All right, as I looked at it here, and as Barbara assigned me my task today, it was to try and give you some input on the considerations here about Section 16 in comparison with the old Section 9. One of the things that struck me here is that, first of all, in terms of the input of a client here, as that age group that you deal with becomes older, I think you will find, as you all know yourself, that the difference between a 12, 13, 14, 15-year-old and someone who is 17 or 18 is really going to be crucial. You're going to get instructions, obviously, from an older type of client, and that client obviously perhaps may not want himself, whereas the thrust before was that they always wanted to stay down, they wanted to stay in the juvenile system, they didn't want to go into the adult system, they had heard horror stories about it. I think you may be getting in the future 16 and 17, 18-year-olds who say to you that they don't want to be in juvenile facilities and that in fact they're quite ready, this macho thing that they have, they're quite ready to go there with the big boys, and that they don't want you fighting a Section 9 hearing, they're quite happy to go into adult court. Another factor is in terms of, a lot of these considerations are very difficult to see how they'll all gel. The review procedure, for instance, you've got in Section 20 your limitation of, on the most serious offenses, of a 3-year sentence, and then you've got built in your yearly review hearings, again, how practical they'll be, what success they'll have, will it lead to early release because of the pressure on these institutions to get rid of bodies. That'll be another factor which you'll have to consider in the future. Well, bearing all of these things in mind, and that I'm going to make comments not knowing how these things will gel, one of the things then clearly that you've got to discuss with the client will be advising him that you now have a top limit in your sentence of 3 years. And with that top limit on the very serious offenses, I think a young fellow, whatever the age, or a young person, whatever the age, has to bear in mind that for serious offenses that it could be transferred to adult court, you really have a huge, potentially huge discrepancy in your sentencing factors. The limit being 3 years, and then a situation like Mike mentioned, a limit where you could have 10 years, 25, what have you. As well as that, if that review procedure becomes practical, if it becomes effective, you really could lead to very early release on behalf of clients here after a year. Another aspect here to bear in mind is the role, as Mike alluded to, that the parents may actually play on that hearing. Before, their role was very unclear. I think here, under Section 16, they must be given an opportunity to be heard. It seems to me that we may in the future have problems. I haven't generally encountered parents that wish to see their child go to adult court, but still in all, there could be the procedure where their interests are not necessarily the same as the child's interests. Do they have a right to be represented? They certainly have a right to be heard. You certainly could have a three-cornered hearing, if you like, where there's yourself, there's the Crown, and there's parental input, but which really may be opposed to what you consider the overall plan or tactic that you have or approach that you wish to take. It's a thing that in the past it used to be that it seemed the parents were in one and the same camp as you. I think in the future here there's quite clearly the prospect that parents may be there flailing away at their interests, and those interests may not necessarily be the same as your client's interests. Something else which I think we've all seen in the past is that ComSoc has been involved with an awful lot of these individuals that have come forward for transfer orders in the past. I think they were, nothing pejorative meant here, they were involved with wards. Crown wards often got into trouble, got into serious trouble. ComSoc, if you like, was like a surrogate parent to them. When a Section 9 hearing came around, you dealt with ComSoc and the child to a large extent. ComSoc had many resources. They had great input. They had many wilderness camps and plans and psychiatrists and psychologists. They were deeply involved in the hearing. With the ward concept having been eliminated here, it seems to me in the future that defense counsel will have to plug themselves in to the resources that ComSoc had. You won't necessarily get that spontaneous input from ComSoc because ComSoc won't have been involved in these children's life prior to the Section 9 hearing. They are still there, their resources are still there, but the input they had before, where in a sense that child was almost like their child, where they had his records, where they were very familiar, you won't necessarily have that. It'll be up to you to find that and get that information yourself. However, will those individuals who will participate in the review, the yearly review procedures, will those people in those facilities now have a larger role? And that is, will they be the people that we will call forward to describe the kind of plans that there are in the juvenile facilities as opposed to the kind of plans that there might be in an adult facility? I think they are. I think they're the people that you're going to have to tap, and they're the type of people that you're going to have to bring in. It seems to me they're, if you like, jealous of their jurisdiction, that they'll come in there, that they will give you descriptions of the type of plans, the psychiatric treatment, the counseling that they can give, and I think they're the people that you're going to have to use in the future. With respect to evidence, again, that Mike alluded to, one thing that concerned me was it seemed that in the new act you can be assessed to death. And under Section 13, for instance, Section 13 reads, for the purpose of considering an application under Section 16, for the purpose of considering an application under Section 16 and in other areas, but they don't concern us here, a youth court may, at any stage of proceedings against a young person, with the consent of the young person and the prosecutor, or on its own motion, or upon the application of either the young person or the prosecutor, where the court has reasonable grounds to believe the young person may be suffering from a physical or mental illness or disorder, a psychological disorder, an emotional disturbance, a learning disability, or mental retardation, and where the court believes a medical, psychological, or psychiatric report in respect of the young person might be helpful in making any decision pursuant to this act, well, it can order him examined, and it can send him away to be examined. I think one of the concerns that you'd have here is perhaps the concern you have in adult court at a bail hearing, where these psychiatric assessments can unfortunately get the client in there making a lot of admissions contrary to his interests and open an enormous can of worms. And I think that your Section 9 hearing, there's no question that the judges are influenced, or Section 16 as it will be, as it is, will be influenced by the strength of the Crown's case. And if you've got a psychiatric report in which the young person has, out of remorse or many other factors, given a blow-by-blow account of a very heinous crime, you've got a difficulty there, there's no question. And that's a problem that has expanded, I think, the Section 16 hearing. One thing I wanted to mention was the possibility here. It seems there's many areas in the Act for consent doing away with certain requirements. I don't think that there's any implication here that you can consent or agree with the Crown to circumvent the Section 16 area. I don't think you and the Crown can necessarily go in and say we're both in agreement that he go to adult court. However, I do think there's probably room here, as the whole Act is very creative and very concerned about the young person. There perhaps is room here where you could work out a bargain on the basis that you would agree to a sentence subject to the court's discretion, and that your client may, I wonder how enforceable this is, but it has been put to me, that your client may in fact agree that he would either waive the yearly reviews, or if he didn't waive those yearly reviews on a fixed sentence, that he certainly wouldn't actively seek his release. Therefore, you might get a very serious crime where he stayed down, where he got a 2 to 3 year sentence, and where he would be in a program which he was aware of, and which he would have the discretion that those officials have to move them from institutions and to different programs, and the Crown would be assured for their part that you wouldn't have somebody perhaps on a very premature release. Could you do that? I think that area is open for the future. One final thing here on the appeal route that is contained in that section. I think the appeal route here is far less cumbersome than it was before. Before, there was no specific appeal route for your Section 9s. You were caught by the general, as I perceived it, Section 37 under that old Act, and you had to have special leave, and that wording was, the wording in any event set out its own criteria, I'll get it here for you. In Section 37(2) of the Old Juvenile Delinquents Act, no leave to appeal shall be granted under this section unless the judge or court granting such leave considers that in the particular circumstances of the case, it is essential to the public interest or the due administration of justice that such leave be granted. So A, you needed leave, and B, you had these two grounds to consider. I can assure you that when you went for leave, you could even be met with the prospect of a judge going so far as to say, well, I wouldn't necessarily have transferred him, but then again, I'm not here to review that discretion. He considered all the appropriate factors from the Merrow case and what have you, and therefore your child is transferred. Here, your time factors are not as stringent. You have your standard 30-day period. You're not caught, as sometimes you were in the past, with that 10-day period. You appeal on different, your appeal right is more generous, as you see in that Section 16, the prosecutor yourself, and there shall be an appeal. And as well as that, the wording is different. Others don't make much of this, but as I see in the wording here in Section 16 sub 9, where there has been a refusal or what have you, I'm reading from line 2, the court shall, in an application of the young person or his counsel or the Attorney General or his agent, made within 30 days after the decision of the youth court, be reviewed by the Superior Court, and that court may in its discretion confirm or reverse the decision of the youth court. You appeal to a Supreme Court judge alone, unless, of course, your youth court was a Superior Court itself. But I think in most instances here, you're going to be at the provincial court level. But there's the review again, and again we have that differing case law on our bail reviews. You know how you have the case law whether a bail review is a review, a complete review in which he can substitute his own discretion, or whether it's an appeal, and you have to find, if you like, an error of law. There it says it's a review, and I think you'd argue there if you had been transferred kicking and screaming, and you didn't want to be transferred, I think that you would take the position there that there's a broader area to be reviewed there, and try and get that Superior Court judge to get involved in that file again and to see whether the considerations that had been made by your family court judge were appropriate. I think that's about all that I can mention here. Section 15 says that if he's had a predisposition report, he should be disqualified from a hearing unless on consent. I think you'd want him. I think if you had a judge on a Section 16 hearing, if he had had a predisposition report and heard your plan and agreed with you and kept that child down in juvenile court, I don't think I'd want to disqualify him. I think I'd want that fellow, because if he had stayed down and bitten on your overall plan for the child, I think you'd be a long way then to striking a bargain with the Crown, with the plea, and getting him to implement the very bargain, if you like, or the very plan that you had in mind. So I certainly wouldn't avail myself of that section. Barbara, that's about all I can.
Yes. Les Horn, for a long time in Ontario, we, as Mike said, only brought applications on murder cases primarily. And then we found that there was a trend within that ministry to place their wards, once they were committed to training school, within the community. And we found that they continued to commit further offenses, so that it became necessary, at least from the Crown perspective, to offer some hope to the citizens to be protected from these people from continuous break-and-enters. So we commenced a plan of bringing applications on break-and-enter offenses that hitherto we had not done, and on armed robbery cases. And we had been successful in some of those applications, and they sort of sprung up all over the province. Well, because they were so new, really, to Ontario, the Ministry of Community and Social Services felt that it was incumbent upon them to assist these wards primarily, because they were basically training school wards who'd been placed all over the country. And they provided a child advocate service for them. And this child advocate service was run by Les Horn. And he would go around and he would assist the defense counsel by giving them transcripts of the previous applications that have been done, by presenting plans to them, and so on. So in terms of a resource person, I suppose, he might be one that you might turn to find out what availability there is for programs within that ministry. As well, a lady called Beverly Parker, as I understand it presently, is in charge of the custodial aspects of this legislation when you get a sentence of custody. Now that's the central region. She'll have counterparts in other areas of the province, so I suppose the person who might be in charge of that might be a person to turn to see what kind of facilities there are in open and secure custody within that ministry. Presumably these applications would be taken on offenses that would only look to that kind of a disposition should they be continued against in the Young Offenders Act.
I'd recommend Les Horn. He was the bane of Barbara's life. He's a walking compendium of all the resources they have. He's a great witness to boot. You don't even need to subpoena him.
As you can see, it was always a great uphill battle on part of the crowd. And I sympathize with Mike when he says, how do you prove it's in the good of the child to be transferred for 25 years? But somehow he managed to persuade them in that case that was his good. I should alert you to Section 17 as well. When you are counsel in these cases, it is your ban of publication. And if the accused young person doesn't have that, a counsel representing him, the court has to give him that order. Now, in all likelihood, I can't imagine doing a transfer case without counsel representing the accused. So if there is counsel representing the young person on a Section 16 application, you have to apply for it. So you might want to consider getting that protection for your client. And it does have to come from you. It's interesting to note that we run into trouble in the French and English translations here, because in the English translation you have the term that they can't report on any information respecting the offense. And I thought that was rather bizarre, because obviously it's not the offense that you're concerned about with at that point. It seems to me you're really concerned about his background becoming known to any subsequent potential jury members, and that's really what a transfer hearing is all about. What kind of a sentence is he going to get if he's convicted? And so all his background's gone into. But I'm advised, not being bilingual myself, I have to admit that the French version cures all that and says the proceedings, so that in fact you're protected against all the evidence that comes out at a transfer hearing, not just that portion that relates to the offense itself. Another point that's of interest, and I don't know what we're going to do about this in the future, it's certainly ambiguous as to whether or not, supposing you brought an application for a transfer hearing and it was denied and the appeal route was exhausted, seems to be a suggestion that then what was led in the transfer hearing might be subject to reporting before a trial was completed or commenced, even if that trial is taking place in the young offenders court, in the youth court, because there's a prohibition if the trial is going to be heard in the adult court, but that same prohibition doesn't seem to be indicated in this section if the trial is heard in the young offenders court. So I point out to you that you might want to look at that protection for your client and make that application right away if you are involved in a transfer hearing. Statistically, these have not been great. I asked Les's office, he was out of the office, what the statistics were because of this committee. He is in charge of the whole province. And his secretary advised me that there was 1 transfer last year, 2 I think the year before, and 4 the year before that, and they've been averaging between 4 and 1 in the last 5 years, say, that were granted to the adult system. Now, of the population that were considered, it went as high as 14 cases in 1 year that were considered. Some of those were withdrawn and some of them were dismissed that year. So we're not talking about a large number here, although with the age factor of 16 and 17-year-olds, that might change. What do you think, Mike?
Well, I expect that it will change and increase. Just how significant, of course, remains to be seen. But by far, in an overall view, a high percentage of crime is committed by this age group. And so the Crown will certainly, I expect, be considering these applications more frequently.
We've
probably wrap this up as quickly as we can, and perhaps we can give you an extra couple of minutes on that lunch that you have coming up. I'd like to thank Fred Shanahan for his participation today and Michael Lynch for assisting us.